But I do want us to go ahead and get started. And Judge Parks, I will, after I turn my camera off, I can hopefully facilitate that. But I'd like for us to go ahead and get the ball rolling today for our litigation webinar. Perspectives from the bench. I'm really thrilled to have everyone here with us this morning. Thank you so much for giving your time to us and to sharing your expertise with our attorneys. Allison Jackson is going to moderate our panel today. Hello, Allison.
Hi, Allison.
Allison is an attorney with, is it Egerton? I'm sorry.
Edgerton, McAfee, Armistead, and Davis. Hard to say.
Okay, yeah. Well, that Edgerton, yeah. At any rate, Edgerton, McAfee, Armistead, and Davis in Knoxville. And she's also the vice chair of the TBA's litigation section executive council. And she was instrumental in putting our panel together today. So thank you, Allison. And I will hand the floor over to you and see if I can't get old Judge Parks on the line with us. So thanks again.
Thanks, Brooke, and thank you all for joining us today. Welcome. It's 12:30 in Knoxville, so good afternoon or good morning, depending on where you're located. We're so glad that you've joined us for this moderated panel discussion this afternoon. As Brooke indicated, my name is Allison Jackson. I am a shareholder and civil litigator with Edgerton McAfee in Knoxville, where I practice primarily handling business and commercial disputes, construction litigation, labor and employment law, and conservatorship matters. And so today we're joined by an esteemed panel of our judiciary, judges from across our state, to discuss sort of best practices, tips and tricks, insider information about how to get great results in the courtroom for your clients. In ways to avoid maybe common pitfalls or things that we tend to do that perhaps we ought not. So without further ado, what I'd like to do is give each of our panelists an opportunity to provide you with their background and biography. And we'll start with Judge Wagner of the Circuit Court of Shelby County.
Hi, good morning. I am Judge Wagner. I am a circuit court judge in Memphis, Shelby County, one of the 9 circuit judges, and on the bench since 2016. And our circuit court in Shelby County does only civil cases.
Thank you, Judge Wagner. We'd also like to welcome today Chancellor Jenkins of the Chancery Court for Shelby County as well. Chancellor Jenkins, would you provide us with your biography as well, sir?
Good morning. I'm Joe Day Jenkins. I've been a chancellor for approximately 7 years, just recently reelected, and I handle only civil matters in Shelby County.
We're also joined today by Judge Russ Parks, who is judge of the Circuit Court serving Giles, Lawrence, Murray, and Wayne counties. Judge Parks, welcome. Oh, we've got you on mute, Judge. If you'll just unmute that and tell us a little bit about your bio, that would be great.
My name is Russ Parks. I'm one of the 4 circuit judges in the 22nd Judicial District serving 4 counties. We have general jurisdiction, so I have both civil, criminal, and domestic jurisdiction.
We're also joined today by Judge Adrian Fry, judge of the Circuit Court serving Montgomery and Robertson counties. Welcome, Judge Fry. Would you please introduce yourself?
Sure, and thank you for having me. I am a circuit court judge for the 19th Judicial District that's made up of Montgomery and Robertson counties, which serves Clarksville and Springfield. I was appointed to the bench August of 2021 and then was successfully elected. So I'll start my full term. I am part 1, which does primarily torts and almost exclusively civil litigation. A very small portion is dedicated to domestic relations cases and misdemeanors that happen to make their way up to circuit court.
Very good. Thank you so much. We also have Chancellor Jerry Bryant, Chancellor of the 10th District Chancery Court serving Bradley, McMinn, Monroe, and Polk counties with us today. Chancellor Bryant, would you please introduce yourself as well?
Yes, I'm Chancellor Jara Bryant. I've been practicing, or I've been a chancellor since 1998. I guess I'm the oldest one on this panel. Serving those counties, and prior to that, I practiced law in Knox County and then back down in my judicial district.
Thank you. And last but never least, we're joined by Judge Justin Angel, Judge of the 12th Circuit Court, serving Bledsoe, Franklin, Grundy, Marion, Ray, and Sequatchie counties. Welcome, Judge Angel. Would you introduce yourself?
Thank you, and thanks for having me. I'm Justin Angel. I'm a circuit court judge in the 12th Judicial District. I preside over criminal and civil matters in those 6 counties. So, and also chancery matters at times, probate, domestic. And I was elected back in 2014, and I was only 31 now. Now I'm 41. So I'm the senior judge in my district now, which is kind of hard to believe, but I've just reelected to my 2nd term.
Welcome. Thank you, Judge Angel. We appreciate each of you for being here, and thank you for being willing to each of you to give us some great insights in how to engage in our best practices when in the courtroom. So to kick things off, we know as practitioners that judges frequently have their own preferences as to how things ought to go in the management of their dockets, and perhaps even how matters are specifically handled in their courtroom. In federal court, it's pretty easy oftentimes to decipher what those preferences might be because they're published. It's easy to sort of snoop on your judges and figure out, oh, here's how they like to have things done, or here's how they like to have things look, or be filed, or be scheduled. And so one thing I'm going to pose to each of you is, do you have judicial preferences that lawyers practicing in your court ought to know? And if so, how do we find out what those are? To Chancellor Jenkins, I would like to start with you, please.
Well, thank you. In the Chancery Court in Shelby County, all 3 parts have published preferences. And you can go to our website, you can find those. And if there are things that that are not included on the preferences, you can always call our judicial law clerks and get the information that you may otherwise need there. One of the key things, and I'm not sure how far you want me to go, but I'll take a couple of steps further. One of the things that we like to see in Chancery is that all of the lawyers presenting to the court need to know and follow the local rules. Because that allows us to mediate a lot of preliminary controversies between the litigants. And so if the lawyers will follow the local rules, if they would submit their briefs in the right font size, and this is a particular problem that I'm beginning to see among the newer lawyers, particularly as they transition from, say, juvenile court or criminal court into the civil litigation, their font sizes are kind of small. Their spacing and is off in terms of they single space, and they use run-on sentences without spacing. So it makes it very difficult and cumbersome to read their pleadings. And then they submit their briefs untimely, the night before, the morning of, a day before, which makes it very difficult to manage the litigation. And then after we've ruled on some of their matters, the orders come in very late. They come in maybe 30 days, 60 days. The other day I had one that was 90 days late. And at that juncture, I pretty much have to go back and take a look at the pleadings to see what I decided, to make sure the order comports with what was ruled upon, or better yet, may have to call the lawyers back in to tell me what we did on that matter. So those are some of the preferences that, that we like to keep the lawyers up to speed on. Submit your orders in 7 days, and that's not a problem. I think I'll cut it off right there.
So much, Chancellor Jenkins, and I'm seeing a lot of head nodding. There were some comments that I felt like got some traction with some of our panelists here. Chancellor Bryan, I noticed you were kind of nodding your head along too. Is there perhaps maybe a top 3 things that you see, or even a top 5, whatever your list might be, that you could provide in terms of giving insight and wisdom to those who practice before you on how we can get it right?
Well, the first thing you need to know, and it's not in our local rules because we haven't updated them since COVID, but I do what I call docket triage at 4:30 the day before your case is set to be heard. And that is a 5-minute, everybody pop on and give me an amount of time that your case is going to need. And I try to put the shorter cases on first and let you know if you're going to be bumped, or let you know what time to come in for trial. I might have a whole morning full of other shorter matters, and you may not need to be there till 11 o'clock. So that's something that we do that's different from our local rules. And if you're from out of town, you probably don't know about it, but you'll get a Zoom invite that's for a docket triage. I'm on Zoom every day. The next day, you'll get a separate Zoom invite for court. If you want to do your court by Zoom, we can handle that request on the Zoom invite, the triage the day before. But that's something that's probably not in the local rules. Most of our other stuff is there. Because I cover 4 counties, I like to have a copy of your motions, but when you file them, file a duplicate copy for me if it's something that you want me to read before court. I don't drive to Monroe County to get their stuff because I'm usually in court all day the day before. So absolutely, on motions for summary judgment or dispositive motions, I'd like to have my own copy of that. And as Jode said, not the night before. Do not fax my office at 5 p.m. the day before your hearing is and run 150 pages. And I'm saying this from actual experience into the floor. And my secretary have a panic attack when she walks in the next morning and finds that there, and I'm not even at my office. I'm in another county because it won't be read. And it just is the way that we have to manage our docket. So particularly for Knox County practitioners, understand that I know that Adrian and Justin and Russ and I all travel for our district. So we do not have the files ahead of time. So that would probably be something you just need to know.
And that's a great point. That's something I think as practitioners that we tend to wrestle with. What is the perfect time to file something so that our judge is prepared, our parties are prepared, but maybe we don't want to give the other side sort of an upper hand, if you will, by being too prepared. Are there some good guidelines especially from those of you who are traveling amongst counties, in terms of how far in advance of a particular hearing you do expect to have briefs and papers filed? Judge Parks, can you speak to that?
Well, I do, and some of my preferences. I'm one of 4 judges in the 22nd Judicial District, and I think our preference for all of us would be we want the lawyers to be prepared, and part of that is getting us prepared, which means not sending us something the day before, because we are in court, we service these courts, and we take documents home with us. But if you're going to give me a 28-page brief that you could have given me 4 or 5 days in advance and let me educate myself on it, that is certainly our preference. I still feel that we're all under the comprehensive plans, which requires that we stagger our dockets as best we can. And like Jared Bryant, the day before, I will send out a scheduling order, and I do that based on estimates of time that I've received from the lawyers. I'll put the short matters first because I try and avoid having litigants come over there and for a 9 o'clock docket, and I know that their case won't be heard until 1 or 11. So I'll put 2 or 3 at 11, 2 or 3 at 1, and so forth, and try and manage people getting in and out as best I can. So that, and I still have a lot of Zoom hearings, and I approve a lot of pleas in criminal cases because they suspended Rule 11 that said we don't have to address those individual defendants in open court. However, if we ever get away from those comprehensive plans and the Supreme Court says we're no longer under those, we won't be able to do those without Rule 11 being changed. So I think all of us probably have a common request. That is, get us if you want us to read the things, get them to us at least 4 to 5 days in advance.
Mhm.
Thank you. And so it seems like thus far, just timeliness, common courtesy of the court, being aware of the court's time, being aware of the local rules and the local requirements to make sure that your pleadings comport with those local rules. Judge Angel, can you speak to any specifics in your court that we ought to be aware of to make sure that we are doing things as Your Honor would please?
Like Russ and Jara, Adrian, we travel around and some of us don't have law clerks. I have 6 counties, civil, criminal, no law clerk. And so do you think I would like a 5-page brief or a 50-page brief? You think I
know which one you're leaning towards.
You think I want your 3 best case sites or 30 case sites? So just, you have to know your audience and know what we have time for. You really want us to comprehend what you're sending, and the more you send us, the earlier you need to send it to us so we can be prepared. Now, some attorneys can show up the day of court, hand me and opposing counsel to their best cases with the relevant portions highlighted and say,
Amen.
Judge, I'd like for you to look at this portion of the case. And you're standing right in front of me. I have the case in my hands and I'm looking at the highlighted portions. That can be a very effective way for me to zero in on the issue in the case. And also, I want the attorneys to talk before court. I mean, isn't that shocking that they'll show up for court and I say, when's the last time you discussed this case? Well, we haven't talked about it. Well, let's talk about it. You should come in front of me as a last resort. You should agree on everything you can agree on, be reasonable, put it in an agreed order. Don't even have to come to court if it's an agreed order, obviously. And on the criminal side, the same thing. The DAs need to be reasonable. They need to talk to the defense attorneys. They need to negotiate the cases the best they can and come in front of me, as a last resort.
That is great advice. Yes. How frequently, and perhaps Judge Fry or Judge Wagner could speak to this, is it a common issue that you find that attorneys do come before the court on contested matters that have not been discussed in some time? How often is that a problem?
I'll jump in. I would agree with Judge Angel. We see all too often that attorneys are coming to court and either before status conference or a motion to compel on a discovery issue, and they've not chatted. They may have exchanged some emails a little bit, but that would be a best case scenario. And I guess I'm a little bit old school. I'll ask them that question that Justin asked. Have y'all chatted about this? And they'll say no. And I said, well, why don't y'all make use of my jury room? There's some coffee back there. Go back there and have a chat. We'll come back to you in a few minutes. And I'd say probably 80% of the time, most of their issues are worked out once they've had that conversation. And so especially before a motion docket, we have a local rule in Shelby County that you have to certify that you have consulted with opposing counsel, and you've got to put that certification on your motion. And we'll strike your motion if you don't have that certification. So I would really encourage attorneys to do that.
Thank you, Judge Wagner. And Judge Fry, just to give you the opportunity, do you have anything additional to add in terms of preferences that we ought to know about before Your Honor?
Well, first and foremost, I'm enjoying hearing all of my colleagues, and I'm actually taking notes about the triage that Chancellor Bryant just pointed out, because oftentimes it is where I understand, and being new to the bench, I understand from private practice, oftentimes you have to get that date even to foster some type of communication between parties and between litigants. So I understand that, but then I think that kind of the realization that I've had in my transition from the bench is that I'll have 5 cases set, and the morning of have attorneys come in and say, well, if you give us 15 minutes, we may be able to work this out. And so it is the frustration of having so many cases fall through the day of, or settle the day of, and it's really something that could have been discussed a week prior and freed up some of my docket for other matters. But just to reiterate what everyone else has said, our local rules provide a very good guideline. And I know the 19th, we're restructuring some of ours. And for us, on Fridays, we have 5 circuit judges and 1 chancellor. And on Fridays, we almost all have motion dates. So it's kind of the Wild West for attorneys to run in and talk with one another, and just for individuals coming up from other districts, it's really helpful to communicate prior to that Friday date so that we can maximize our time. But really, this is great hearing what other districts do too. And as far as a preference, just I'll put this out there. I do hear healthcare liability actions, and I have a standing order that I send out anytime a new case is filed that just kind of outlines how I expect scheduling orders to go, how I expect expert testimony to go, and disclosures and things like that. So that is something that I've tried to do to streamline cases that can oftentimes grow legs and get larger and larger.
Thank you. That's so helpful. Switching gears just a bit. For some time, practitioners have debated and discussed the importance, or perhaps the lack thereof, of oral argument. How significant is oral argument in our cases? Frequently, it's thought that briefs and other paper filings are more persuasive and significant to the court's decision overall. But I'd really like to hear it from each of you, the weight that the court places on oral arguments versus briefs and other paper filings. And Judge Brian, I'd like to start with you if we can, please.
That's always something I think about. I will tell you what is not effective oral argument. Reading your brief to me is not an effective oral argument. I've read what you've written. I view oral argument more helpful as, and it depends on the case type. The more complicated the case, then I prefer oral argument to lay out the issues and provide me some law. Like Justin said, I want mine highlighted. I don't want to find that wisdom kernel that you want to refer to on page 19. So I want you to highlight it for me. And be there for questions. Be ready for me to stop you and ask you questions, rather than just read to me. Nothing drives me crazier than for somebody just to stand there and read to me. If you're too nervous and you really don't want to do that, then just say, I'll rest on my brief. And there is not one thing I take away from that, because if you've written a good brief, then I know you're prepared.
I appreciate that. Thank you, Chancellor. Judge Parks, I'd be curious, how do you weigh in on the importance of oral argument versus briefs, and what do you find particularly helpful? Oh, you're on mute, sir. I'm so sorry.
Mute.
I'm sorry, I had to sign back on. The internet is not great in this office today. I'm assuming when you're talking about oral argument, you're talking about motion practice.
That's right.
And for motion practice, that's generally motion for summary judgments and motions to dismiss. If you get it to me in advance and I've read it, I really like oral argument on the complex matters, because I might ask about the applicability of a case that you've cited.
Mm-hmm.
Or is this really a good response to a disputed material fact? Have you made that dispute now? And is it material? So I personally like oral argument. Now, in this day of Zoom, I will almost always designate motions for summary judgment to be heard by Zoom. Saves the litigants a lot of time and money. I had 7 lawyers in a products liability case from 4 different states. Tens of thousands of dollars saved in litigation expense by me handling the oral argument. And they were great. They were fabulous, and they seemed to all appreciate it. So I like oral argument. As far if you're talking about oral argument as it relates to closing in a domestic case, as a general rule, I'll tell them specifically.
Oh, he's frozen.
I think he froze for just a minute. So we'll pop over to Judge Angel. Judge Angel, what for you makes a particularly compelling oral argument? And then conversely, what aspects are to be avoided in your court?
Well, I do prefer oral argument, and I was a litigator and I have a soft spot for litigation. I just think other litigators, we say a real lawyer goes to court and argues. And so I don't want to ever get away from that. I want people to come to court and argue and really ferret out their case in front of the judge. But it's really affected me, like Chancellor Bryant said, when you have it highlighted and we know what the issue is, and maybe it's a close call, and it does take some persuasive arguments to say, Judge, this case is different, but this is how this applies. And then hearing the other attorney pop up and give the counter argument. And to me, that's just a really effective way to present the arguments to me and maybe look at it from an angle that I didn't even think about. And I can make a decision at that point. So just being confident in your argument and presenting it in a way that can convince the court that to rule in your favor.
Thank you. And flipping over to you, Judge Wagner, I'd be curious what your thoughts might be in terms of what aspects. So it really seems that oral argument is still a very significant factor to the court's decision and ruling on especially dispositive and other important motions. But what elements of a brief lend itself to prepare the court for a good oral argument? What are you looking for us to do in our briefs before we come to court to argue before you?
So I want your briefs to lay out all of the issues, and I would agree with what Justin said. If a 50 versus a 5-page brief, we've got a lot of reading to do, clear and concise. One, it's easier to follow the more concise it is, but also it helps us with time management. But make sure you include all the issues. One thing I hate is when a lawyer walks in and starts making a legal argument in court. And I'm like, counsel, I don't remember seeing that in your brief. I have no idea what you're talking about. So giving us a heads up as to what the issues are. And then, I'll repeat what Jared said about oral argument. Focus on the main issues, clarify anything that needs clarifying, be ready for questions, because it's a great opportunity for me to ask anything I'm unclear on or ask for a response to the other side's argument. I don't need you to read me your brief. I've read it, and that's frankly boring and a waste of everyone's time.
I appreciate that. Judge Fry, question to you. What aspects do you find other than either brevity or the lack thereof, what aspects of a brief are not particularly helpful to the court as the court prepares to hear oral arguments in a given case?
Sure. I think just to kind of follow up we all remember from law school, the Iraq issue rule application conclusion. And so having a brief that is succinct and has all of those portions kind of put together in a way that's easy to read and easy to review is definitely the most really helpful and tracking your oral argument to go along with that. So I've experienced where attorneys might be nervous or unprepared, and so they jump around from issue to issue, and it's kind of like trying to put out little fires and follow, and that's not very helpful for the court.
Can I add one other thing, Allison?
Yes, please.
Your own personal opinion as an attorney is not something that I need in a brief, or name calling. And I'm seeing more and more name calling, or lots of adjectives that, adversary counsel is ill prepared or things like that. I find those just to be detractors and not helpful. So name callings or opinions of the lawyer. In my opinion, Judge, you'll just cause the whole world to end if you rule this way. Those are not helpful.
I appreciate that observation, Chancellor Bryant. And Chancellor Jenkins, I sort of saw you nodding your head over there. Maybe you heard something that you agreed with. What has been your experience in your court? I know you mentioned previous, just attention to briefs and making sure that they comport, but what are you finding in briefs and in preparations for oral argument that is either particularly helpful or conversely particularly not helpful to your honor?
Oftentimes I find that the briefs are excessive in terms of the nature of the argument. Oftentimes I have to go back and reread to see if they actually missed the issues in the case, to hone in on the issues that I need to decide. The briefs ought to help the court focus in on the issue and decide the issue. And the lawyers are not, in many instances, are not doing an adequate job of informing the judge of the issue to be decided and how they want the judge to decide it and what authority there is for the judge to utilize to decide in their favor. I think they can do a lot better job by and large in that. So if I were to say something that should be excised from the brief, it would be the excessive citation. Give me, as I think Judge Angel said, give me your best 1 or 2 cases. Let me know specifically what the issue is so that we can get right to the nitty-gritty and move on.
I appreciate that. And I think someone raised this just a moment ago, and I'm just curious, show of hands here. Do any of our judicial panelists have a law clerk who is helping them ferret through these issues and cases? 1. Wow.
And I'll qualify, I have a third-year student who works part-time. So I do have some help, but it's not a full-time law clerk you might expect.
Gotcha. So in terms of distilling the issues, framing the issues before the court, making your position known and making your client's best case, it truly is in the best interest of the lawyer and the client and the case overall, to really be targeted and directed, because it does seem that the court is by and large doing its own exercise, going through these briefs, finding these issues and narrowing things down to help decide these cases. And is that sort of a correct understand? That's what I just got from this, is that everybody's really busy and we have a huge lack of resources in terms of time.
Yes.
Thank you.
Let me say this, I have considered placing a maximum number of pages on brief. I'm still considering that because, you know, we're getting, in some instances, I think I picked up one the other day and we got the briefs 3 days before, but it was a 28-page brief with an appendix of about 75 pages. And then it had exhibits on top of that. That was truly excessive. And I don't know if we need all of that. I doubt it. But I think a page limit may be in order unless they can justify why they should go beyond, you know, a reasonable amount of pages. And I don't know what that number would be. But hopefully Mary and her colleagues will give me some advice on that.
Well, and just curious, so you mentioned having received that very voluminous brief only 3 days prior to the hearing. When briefs and pleadings like that are filed that are large and have appendices and have exhibits, and there is a lack of time in advance of the hearing, as practitioners, realistically, what can we expect our judge to have done to prepare? Should we expect the judge to have done as much as they can and gotten as far as they could through the brief? Should we expect to show up and the judge says, hey, we're going to have to reset this because you've dumped this in my lap and there's no way I could distill it? How have any of you handled that issue in your court, if you have?
Well, on that particular one, I had my secretary to call and let them know that we were not proceeding on that matter. And we pushed it out far enough so that we could have time to absorb the arguments. And one other thing, I'll add this now, I'll be done, is that in Shelby County, we have electronic filing. And often the lawyers will file their briefs or attempt to file their briefs online or with the clerk. That is not the way to do that. And what they should do, as in all matters that come before judges, is they should bring a matter to our chambers. The pleading should be brought to our chambers so that we can manage our time as to when we can read those documents and be prepared. What we all want to do is to be fully prepared to hear the argument when it comes before us, so that at the time that we hear the arguments, having read the briefs, when we're done, we can make a ruling. But if we're not in that position, it makes it very difficult for us And, over a period of time, when lawyers continue to present or to be late in their filings or not diligent in those filings, it leaves somewhat of a cloud over that lawyer.
If I could jump in on the e-filing, I think that's an important practical tip to know for the counties. And I don't know how all the other counties work with e-filing, but as Chancellor Jenkins said, in Shelby County, if you e-file something, as a lawyer, I would get an email that said, oh, the opposing attorney filed this, and I would get a heads up, but the judges don't get that email. So if I want to know if there's been a response filed or a summary judgment that's set next week, I have to log into the system, and then I have to pull up the docket number, and then I have to dig through and review all the pleadings to see if I can find what might be the response. And so it's pretty cumbersome on the judges and time consuming. And if you would deliver, as our local rules require, a copy of your brief in a binder and organized, it's just tremendously helpful. I will take some via email if they're smaller sized, but if it's lengthy and a lot of exhibits, a binder organized is tremendously helpful.
This is a motion to dismiss I got in a case. That's a motion to dismiss. It's too much. You can tell the attorneys who get paid by the hour.
Point well taken.
Allison, I can tell you that I had a motion for summary judgment. The responses, the response to the response, and the response to the response to the response, all the attachments were over 1,700 pages, 158 allegedly undisputed material facts with responses, citations to the record, deposition attachments. And I got the last response 5 days before. So I got on the phone and I called them and I said, there's no possible way I'm going to digest this. I think all of us want to rule from the bench whenever we can. And it makes it impossible for us to do that when you have a mass of information come to you 2 or 3 days before. And I think all of us want to walk in that courtroom prepared. Almost all of us were litigators before. We know how important it is to walk in prepared, and we want those people to walk out knowing what our judgment is. We don't want to have to take something under advisement. At least I
No.
don't, but
No.
you
No,
have to unless everybody gets everything to you in advance, which allows you to ask the pertinent questions. It allows them to answer those questions, give the citations, and then hopefully you can rule from the bench with a court reporter there. I don't think anybody would disagree with those.
I appreciate that insight. Thank you so much, Judge Parks. Switching gears just a bit, we've alluded to some perhaps new technologies, new strategies that our courts have employed, particularly since COVID required that many of our courts adapt their operations with sort of innovative strategies and technologies, including the use of virtual hearings, virtual triages, and so on and so forth. Question, and I'm going to ask this of each of our panelists, and we'll start with you, Judge Parks. I'm curious, A, are you still using virtual technology in your court? And if so, tell us how you're using it.
Well, the answer is yes. And of course, like I said, I have general jurisdiction, so I do all of the arraignments virtually through Zoom. When I do a scheduling order, when I have a blend of chancery and circuit court matters, I will send out a scheduling order that says that I will hear these at 9, these at 10, these at 11, and so forth. And I'll mandate a number of those to be by Zoom. From a chancery standpoint, I know we have some chancellors with us. What's better for a litigant than to be able to not have to miss a day of work, be able to sign on and get something done, and the lawyers be able to stay in their office and not have to leave their office and be able to handle, let's say, a divorce in Murray County and another one at the same time or 10 minutes later in Lawrence. That you couldn't have done that without Zoom. So I think the pandemic forced us to learn things as a judiciary that maybe we should have learned well before March of 2020.
I appreciate that. Judge Angel, are you using virtual technology in your courtroom? And if so, how are you deploying it?
I am, and my buddy Russ laid out the benefits of Zoom. I use it all the time still. You know, when during the pandemic, you know, I may have been exposed to COVID, but I had court in Marion County or grand jury, and I would have them show up and get on Zoom, and I do it from right here in my home office. And I had my driveway was iced over one day in the winter, and I couldn't get out of my driveway, and I held court from my office. Before I would have had to just cancel court. So I mean, just there's so many uses of it, and Russ laid that out. The most beneficial thing that for me that came out of e-signature, came out of the COVID situation was e-signature. And I use e-signature now to sign orders that are sent from the attorneys. Instead of mailing it to my office in Pikeville, I may not go to that office all week because I have a homicide trial in Winchester. And so what you want me to sign is sitting on my desk. Now you can email it to me. I can sign it from my phone anywhere. I use that for probation warrants, TBI, search warrants. It's been a game changer. So e-signature is something that I use a lot, and the attorneys love it.
That does sound like that would be particularly useful and very convenient. Judge Wagner, I'm curious which virtual technologies you're using in your courtroom as well.
So I would mirror what everyone else is saying. We're still using Zoom, albeit not as much as we were maybe in the brunt of the pandemic. We still status conferences, which generally take 2 to 3 minutes. Those are all available by Zoom. There's no sense in driving downtown or across the state for a 3-minute appearance. Motions, we do allow Zoom. I do require them specially set if you're going to be on Zoom now to give us a heads up. It got a little too chaotic on our motion dockets on Friday morning. We didn't know if you were coming in person or if you on Zoom and those type of discussions. But we do still, it makes a lot of sense. It makes it easier. Someone called last week and they'd been exposed to COVID and didn't want to come to court. I said, sure, we'll just turn the Zoom on. We had a heads up, and it saved us having to reset the hearing. And so I think Zoom will stay around for those purposes. And like Justin said, with the e-signatures, I'm not in the courthouse today, but I signed a bunch of orders this morning using the e-signature. And so it's helping to keep things moving. So it's a silver lining of the pandemic, the technology we now use.
I appreciate that. Judge Fry, I'm curious, in addition to Zoom, e-signature, are there any other unique technologies that you've used in your courtroom or explored for use in your courtroom that you're looking at employing to sort of make things more convenient and accessible to public practitioners, et cetera?
Sure. Well, one thing that's not necessarily for practitioners, but Judge Angel hit on it. We recently, on the 19th, we started doing DocuSign for search warrants. And so it's much more pleasant to execute a search warrant at 2 a.m. Without having to knock on the door and just being able to do that. We still have to swear them in via either FaceTime or another method, but that's been very helpful. And certainly with gas prices, I know our sheriff's office was thrilled with that. But just to kind of follow up with what Judge Wagner said too, is we still use Zoom in the courtroom and WebEx. It's very different going from Montgomery County to Robertson County. In Robertson County, we have very little technology that's actually in the courtroom, and it's a little bit more difficult to accommodate to some extent. But in Montgomery County, we do ask that attorneys give us a heads up as to when and who they want to be on the Zoom link. But certainly status conferences, quick motions, it's been remarkably helpful to continue that and just to try to streamline things.
Appreciate that. In terms of, and I know that this is a question that I've often wondered, and probably others have wondered as well. Do you feel like there's any difference in the presentation or how you perceive the case or the delivery of a case that's being handled via Zoom, perhaps on a summary judgment motion or something like that, versus one that you would hear argued in person? Any difference from your perspective? And I'll toss that question to Chancellor Jenkins.
Well, I don't discern an appreciable difference in the delivery from the lawyers. The only problem that I have encountered in Zoom vis-a-vis in-person presentations is the quality of the sound. Now, when the sound is not good, it becomes a struggle to make sure that you're hearing the argument, and it throws you off. And then you end up having to, well, I end up having to punt and requiring them to come in. And it's usually a repeat offender who does that, whose technology apparatus they have not, problem they've not resolved. But on by and large, it seems that the arguments are equally adequate to the court on Zoom as in person. I'd like to throw this out. In Shelby County, and well, not necessarily in all of Shelby County, but in Part 3, most of the lawyers that present in Part 3 prefer in their motion practice to present by Zoom. There are a few who prefer to come to court to present their motions in person. And so as a default practice, I'm having all of my motion practice heard by Zoom, and those who want to appear in person have to request that. So and that allows us to manage the schedule a lot better, to move the litigants in and out, and to make our rulings timely, particularly in the Friday morning motion dockets, where you're looking for defaults, you're looking for, you're hearing discovery disputes. Those types of matters can be heard very quickly, and the lawyers then can have their orders presented the same day or within the hour. And that allows us to move those matters very quickly. Does it create more work for the staff? Yes, but we all appreciate it, and the lawyers appreciate it, and it seems to be working very well to manage the docket, to keep things on track, and to keep the lawyers happy. One final point: pro se litigants are also more apt to want to use Zoom in Part 3 of Chancery Court, because it allows them the opportunity to avoid the parking problems coming downtown. It allows them to not have to take off an entire day from work. It allows them to be heard, whereas in many instances, they may not be able to be heard on a matter because of some of the decisions they have to make regarding childcare or regarding being off from work or going to school, those types of things. So it is really a boon that for us, we want to continue to experiment with, and its usage may be increased in Part 3. We don't use it when there's contested issues and we have to take testimony. I'm sorry, Jerry.
That's okay. I was just going to say, I do it a little bit differently, it sounds like, from what some of the rest of you do. I open up a Zoom link on the day of court, and it's the same one for the whole day. It's open for 8 or 9 hours. And if you're told, for instance, if Judge Fry is told that your case is at 11, she just logs in at 11. I may, as you all know, sometimes court goes a little faster than you expected or a little slower. And they're told when they get their Zoom link, just wait your turn and the judge will call on you. And I set it up where everybody's on mute when they log in, so they have to unmute. Now, sometimes I have to train newbies on how to do that, but it's just an all-day Zoom link. So I may have one lawyer who's not comfortable on Zoom, so they appear in person, and another lawyer in Zoom land, as I call it, and they're both able to hear each other and make their arguments in the method that's most comfortable for them. But I agree with Joe Day and Russ. You know, It lets people who are who find it difficult to take a day off work to get their ID divorce at 9 o'clock and just go on back. They can go to the break room and get something taken care of quickly. So
That's right. And Chancellor Bryan, I have benefited from your Zoom docket. I have participated in her triages. I have participated in the Zoom land when my opposing counsel was in person. And it really does work. It seems a little unconventional, but it works great. And I think just from someone who's not local to those counties, gosh, my clients are sure appreciative in the reduction of their bills for not driving to things like docket soundings and to drive down and wait on a hearing. So I do think that those strategies are noticed and very much appreciated. Continuing our discussion of technology, as we know, litigation technology in general, it can be a really helpful tool for an advocate, whether it's used for a hearing or at trial in a particular matter. The availability, however, of technology in state court is often inconsistent, and its functionality is sometimes unpredictable. I would just be curious to each of you, how do you view the use of technology as an aid in presenting a particular case, whether it's at a hearing or at trial? Is that a good thing to do? Or is that something that you've really seen misfire more than it's been helpful? Judge Angel, I'd like to start with you, please.
It's beneficial if you practice it and troubleshoot it before you come to court. You need to get there early and you make sure you bring your equipment you want to use in case the courtroom doesn't have it. You need to set it up, try it out, and make sure it's going to run flawlessly, especially if we're doing a criminal jury trial and now I've got a jury in there and we're sitting there unplugging things and restarting computers and the speakers aren't working. It slows everything down. And so when it works, I think it's extremely beneficial for the judge and the jury. But whenever it hasn't been practiced or tried out, it can be cumbersome.
Judge Wagner, to you, have you found that litigation technology has been pretty helpful, something that you like to see, or overall, have you seen it just be a misfire?
I love to see the technology being used, whether it's a jury trial or bench trial. I would echo what Judge Angel said about you got to practice with it, know what you're doing. But I mean, to me, if you're trying a jury case these days and everyone's used to the screens and PowerPoints, you really need to integrate some technology into your presentation. We were lucky, another silver lining of the pandemic in Shelby County, we got new equipment in our courtrooms during COVID. And so we've got an Elmo, a document camera, and a screen that you can plug into with an HDMI cord or wirelessly project to from your tablet. And so it makes things really easy to do in front of a jury. Also, even in bench trials, it saves time. I've told lawyers, instead of passing a document to opposing counsel and then passing it to the witness and then passing it to me, just pop that piece of paper down on that document camera and we're all going to look at it at the same time and we're going to keep moving. And so I really encourage the use of technology, but you've got to know what you're doing. I tell lawyers, come in anytime in the mornings or late afternoons. If we're not in session, you're welcome to play around with it, test it out, so that you know if there's any extra equipment that you need to bring, and you also know how to make it work the day of, so there's not hiccups.
Thank you for that, Judge Wagner. To you, Judge Fry, I'd be curious, have you seen any particularly stellar uses of technology in hearings or at trial in your courtroom? And if so, what was remarkable about the employment of technology in that case to you?
I'm glad you asked me this question because I had a jury trial about a month ago and it was a, pretty garden variety car wreck, but one attorney did not use any technology. The other counsel did, and you could see a remarkable difference just in the way that the jury was interested and kind of followed along when they had, especially in closing, where there were just bullet points up on a very simplistic PowerPoint, but it certainly hit home in terms of the damages and what they were seeking. And they even pulled out portions of the medical depositions that they wanted to highlight. And just to see it on a screen and kind of going back to even just what we were talking about with pleadings and motion practices, just to see it succinctly presented, what you want to have resonate was very helpful. And it was not technology that was particularly new age. It was just really a PowerPoint up there on a screen, but it certainly made a big impact. And then the verdict returned was pretty much identical to what was asked for in the closing in that presentation. And certainly, just again, to reiterate, come in, use the technology. I'll say after that jury trial, the next jury trial I had, one of the counsels hadn't come in and used the technology, and it made for a much more difficult day. And so just I've reiterated to every attorney, come in, use the technology, familiarize yourself that we need to do a dry run before the day of.
Thank you so much. And to you, Chancellor Jenkins, if a practitioner is wanting to use technology in your courtroom, what is the best way to try to arrange with Your Honor a convenient time to come play around with the technology, to see what you have, to see whether it works, and what the best presentation might be? How do they approach that with Your Honor?
Well, I let everyone know that while I may be the chancellor, my courtroom clerk runs things around there. And so if they want to come in to practice on the equipment, they need to contact the courtroom clerk. She has the keys to the courtroom, and it's her domain for most of the time. It also helps to bring their own IT person to help to manage any technical difficulties that may arise, because all equipment's not compatible. And sometimes you have to buy stuff or bring specialized equipment in order to sync up what we already have in the courtroom with the technology that they'll want to bring. But I echo what others have shared about the technology. It's very helpful to have demonstrative items to highlight what the lawyers want to impart to the court and to any jurors. So I see technology as becoming a very integral part of our court system. I would like to see more money put into it, and for us to have enough of a budget to have our own staff, part-time, full-time IT people to help us with that. Because when we do have problems, they all break or stop functioning. When we do have problems, particularly if we're in a trial or something like that, we can be down for a while before we resolve the problem, or keeps us moving at a very slow pace. But if we had a staff person there that could respond within minutes to resolve the problem, because usually it's something very simple, it's just that we don't know how to do it. So if we had that, that would be very helpful to us. So that would be a suggestion to you all to see if we can get the legislature to give us more money to have that.
Thank you, Chancellor Jenkins. I appreciate that insight. I'd be curious, Chancellor Bryant, have you seen anything pretty spectacular in terms of technology in your courtroom, or alternatively, any real big missteps that ought to be avoided?
Well, I think it's just spectacular to have it in the courtroom. We've been scratching and clawing and trying to find money to get it into the courtroom. But we now have, believe it or not, in one of my smaller counties, Monroe County, we do have the document reader. We have it pops up on the big 85-inch television screens in corners of the courtroom and on my desk all at the same time. And just like Judge Wagner said, when everybody's looking at the same picture at the same time, it makes the trial go much smoother, and there's less chance for misinterpretation of what happened, or what the witness may be pointing at by the time it gets handed back around or circled or whatever. So I think that's one of the big things that I'm excited about to have in the courtroom.
And Judge Parks, to you, do you find that nowadays, in terms of sort of our CSI exposed society, do jurors sort of have an expectation that there would be some element of technology in these presentations? Or do you find that they come to court with really no expectations at all in that regard?
I think they come to court with expectations. And in fact, I see a number of lawyers void ire on that very issue. I'm old enough where I remember having, as a trial lawyer, I tried over 100 jury trials. I remember having to blow up the jury charge on a board. I'm that old. And I've seen the different generations. Effective use, I as a lawyer would blow up the jury charge, not blow it up, but put it in a PowerPoint. And then I would put, as part of the PowerPoint, under each element, how that was proven. Dr. So-and-so said this as to permanency, it's undisputed, or the defendant said this on the issue of negligence, and so now I've seen that done also here, and I've seen an assistant DA use a PowerPoint with a GPS tracking device that tracked the defendant's vehicle as to everywhere that it was at a given time. It was just so effective, and I think any visual aid is great. And I think the more we see it, and the more these juries see it, the more they will expect it.
Thank you. Keeping things moving a little bit and changing course just a degree. We know that civility is just a core element of attorney professionalism, and that counsel, as officers of the court, really ought to embody civility and professionalism in all that they do, particularly in their role as officers of the legal system and before each of your honors. And I'm going to ask this question to you, Judge Wagner. How do you define for yourself civility and professionalism? What does that look like in the attorneys that appear before your honor?
To me, it's behaving and treating each other, whether it be the other lawyer or the judge, with respect and courtesy, and as your equal. I think it was referred to earlier today about the name calling. We're seeing more of the name calling in briefs or even in court, instead of let's just make your legal argument, instead of calling the other out. The lack of willingness to communicate with each other. Y'all have a disagreement, pick up the phone and chat about it and see if you can come to an agreement. I think as lawyers, it's very difficult, especially in the family law world, to not get personally involved in cases. We can't do that. We have to be advocates, not we as the judges, but as lawyers, advocates for our clients without getting personally drawn into whatever the dispute may be, whether major or small. But treating each other with respect. We may not always agree, but we can discuss and see if we can come to some mutual agreement. If not, that's what the judges are here for, and we'll hear each side. And we'd rather not hear you call each other names or criticize each other unnecessarily. We'll just address the legal issues and we'll move on to the next issue we can solve. So.
Thank you. And to you, Judge Fry, what conduct or the way they might carry themselves or conduct themselves before the court would lend you to think that a particular attorney is very professional in how they handle their matters before the court? What are those characteristics that you see that just strike you as being very professional?
Sure. Well, the preparedness, and then seeing counsels really just kind of refer to one another in a dignified and polite manner. It's easy to show examples or state examples of being rather rude and use those as an exact opposite of the way that you want people to conduct themselves, but not making any personal attacks on one another and always referring to them in a polite manner. And really, it's unfortunately or fortunately, we have a the group of the bar that I think some have displayed behavior that's lacking professionalism, and that gets around, and that's kind of like your reputation. Once you have that marred, it's difficult to come back from. So I would just say that when addressing one another and when referring to one another to the court, instead of saying the kind of crude things, just being polite. And it goes back to, I guess, just really the treat others as you want to be treated. We all have jobs to do, and certainly being an advocate doesn't mean being a jerk. So that's kind of just the general way that I look at it.
Thank you. And to you, Chancellor Jenkins, without exposing those who may be guilty of such conduct, can you provide an example of conduct that may not necessarily violate our ethical rules as an attorney, but that you nonetheless have perceived in your courtroom as being unprofessional conduct or conduct that's unbecoming of a lawyer?
Well, this may or may not be what you're getting to, but it's what's stuck in my mind. And it kind of irks me when a lawyer presents a matter and he is unfamiliar with the case. He's ill-prepared. I think it's very unprofessional of the lawyer to expect the court to educate them on the matter that they're presenting and the case in which they should be familiar with the court. Sometimes younger lawyers are sent to court and they're not given enough preparation by the firm or whoever it is that sent them, just simply on presentation, as to how to present a motion and how to request the relief from the court. And let's say if it's a morning that I am particularly busy and I may have 25 motions or more in rapid succession. Well, I may not remember the exact facts and requests that a particular lawyer is making. And so it becomes very uncomfortable for the lawyer to look at me and me to look at the lawyer. I've called the docket number and it's a very silent situation. And then I begin to have to ask the lawyer, why are you here? How may I help you? What are the facts of your case? What are you asking for? What do you want the court to do? And I began to run into that. So going back to what I think the prior speaker said, just if they're professional, it speaks in their preparedness. We do not have to prompt the lawyers in the preliminary matters of getting the case before the court and making sure the court understands what is being presented and what they're asking of the court. That smacks of good professionalism when those lawyers present in that fashion that the court knows and the court is ready to rule when they finish their presentation.
Thank you. Chancellor Bryant, I'd just be curious, have you experienced lacking professionalism in your court? And if so, have you had to deal with that from the bench? And how did you do so?
Well, I think having been on the bench the longest, I'll start with the curmudgeon approach of first thing. I think that you should look professional. And when you come to court, I have seen lawyers show up in blue jeans. I've seen them show up without ties. I've seen them show up in a pair of pants and a sweater. And I don't think that looks like you have a job to do today and that you're going to be professional. So I think you should look professional. I think when your paperwork is sloppy, it has misspelled words in it. It is when you're taking shortcuts rather than doing the case the appropriate way. Then taking shortcuts is a lack of professionalism. And I can always tell lawyers who are comfortable with their case by how well they treat not only each other, but the witnesses, and particularly a pro se litigant. And I have some lawyers who are so kind to pro se litigants, and you can be kind with and still be an adversary. But I think that those lawyers communicate to the courtroom, not just to me, but to everyone in the courtroom, that they are comfortable, that they're confident, and that they are courteous. And those things, I think, speak of professionalism and civility.
Thank you for that insight. Tossing the question to Judge Parks, I would be curious. Oftentimes, I think it's even been alluded to, counsel litigators may throw barbs at one another, be accusatory in the way that they frame the issues before the court, whether it be over a discovery issue and allegations that maybe counsel or their client was dilatory. How does the court view those kinds of representations to the court? Are they effective? Do they hold ground? Does the court see that as name calling? And if it is in fact true, how does an otherwise consummate professional rise from those kinds of comments?
Well, I can say that I believe that some of the younger lawyers are attempting to make a name for themselves. And I think those are the ones where I see a little bit more of the name calling, or maybe not treating each other professionally. Now, there's plenty of the older lawyers that do it too. How do we handle it as a judge? I mean, there are many times I will say from the bench, they call this the civil practice of law, and they're called the rules of civil procedure for a reason. We're going to be civil in this courtroom. And then there are other times when it's happened over and over, and you almost feel as an obligation to call them back in chambers and say, look, you're being disrespectful, and that is not going to get you anywhere with that lawyer that you're going to face again in a month or 6 months, nor with this court. And so I will talk to them about that. And the other thing that I will add to, I agree with everything all the other speakers have said, be timely. You know, don't repeatedly be the one that comes in at 9:20 for a 9 o'clock docket and say, sorry, judge, I got caught in traffic. And it's the 11th time in a row you got caught in traffic. You know, it's just, I really think that is the ultimate disrespect. Everybody gets caught in traffic every now and then, or the line at dropping the kids off is longer. We understand that. I mean, we get caught in traffic sometimes, but when it's repeated, or when you constantly are saying, calling the clerk and having the clerk deliver a message that you're in a different county, because we service different counties, and saying, tell the judge that I'll be there at 11:30, and there's a 9 o'clock motion. It to me, that is just not acceptable. And I'll tell them that that's not acceptable. And words like, I did a bench bar panel thing 3 years ago, and I asked all the judges to say what their pet peeve was. We all have them. Mine was telling me to mark something for discussion in response to the docket. I hate it. It telling me, and I said, why should I mark it for discussion? The motion's been pending for 75 days. Surely you've had time to discuss it. I'm probably not as kind on the bench as Judge Wagner, who might offer her the jury room. I do that, but the point is, to me, that's a lack of professionalism, and demonstrates a lack of professionalism when you come in ill-prepared or untimely.
Thank you. And last but not least, to you, Judge Angel, I would be curious what your experiences have been as well. Have you seen very much unprofessional conduct in your honors court, and how have you dealt with it?
I have, but I have to say my judicial district, it's kind of like a big family. They all know everybody and they really get along great. So I'm blessed, not to disparage the big city lawyers that come in, but I can tell there's just a different way of practice in some of those more urban or city district, big city districts. But the thing I stress upon the attorneys is showing each other grace. When you have somebody needs to get a continuance because they have a family issue that popped up or a witness issue that's critical to the case, and the other side's like digging their heels in, no, I'm not going to agree to the continuance. We're going to hear it today. Show some grace, because next month, like Russ said, you might need that favor from that opposing attorney. And so when I see the attorneys agreeing on continuances and helping each other out and so forth, and it really goes a long way with me. And also the clerks. If you're not nice to the clerks and to the bailiffs, you will have some I'll have a negative opinion about you as a person, as an attorney as well, because we know the clerk will hand me a Post-it note sometimes and say that attorney called the office or came to the clerk's office and was very rude to us and so forth. So we know how you treat the clerks and the bailiffs as well. And that I don't go for that whatsoever.
Thank you. All great insights. Switching gears just a little bit as we're approaching our wrap up. Good trial skills, as we know, are extremely vital to a litigator's success in our competitive profession. However, I think it's pretty commonly accepted nowadays that perhaps no more than 5% of cases are tried. That means that generationally, trial lawyers are getting less experience trying cases, and frankly, some skills can only be learned from the trenches. Getting some quick insights on various facets of handling cases and managing them up to trial. I want to talk first about case management. What is your particular view on scheduling orders? Are they a good thing, or do they create more problems than they solve? And I'm going to toss that to Judge Fry.
Scheduling orders, I think, are as useful as they are used. And I mean, I don't like to see a scheduling order and then a motion to amend a scheduling order and then a motion to amend a scheduling order, and so on and so forth. I think, and our local rule has a portion in there that says if you have a scheduling order, you can get leave of the court, but generally just once. So as far as it relates to complicated and complex cases, I do think it's good to have those deadlines and have the court aware and the court tracking those, so I know when to start expecting a banker's box full of documents, which I know Judge Parks referenced when he had a full ream of 1,700 pages or 170 pages. I walked in after conference and have a banker's box full of materials for a November 8th docket. So scheduling orders, I do think, are helpful. We don't typically do scheduling orders for domestic cases here in the 19th. I know some other jurisdictions do, but for the most part, they are only applicable to our tort cases.
Very good. And question to you, Chancellor Jenkins, what is the right time to move for a continuance? Is it proper to move the court when you realize you may need one, or is it proper to move the court once the issue is really ripe and you know you need one?
Well, for us, because our docket needs to be actively managed, the sooner I know that this particular hearing or particularly a trial is going to need a continuance, particularly if it's more than a day-long scheduled trial, then I would prefer that the lawyers notify me immediately so I can free that time up for other litigants who are asking for a trial setting. I actively use scheduling orders to manage the cases, allowing for brief status conferences at least once during the course of, say, maybe a 6-month period leading up to the trial, so that I will know that the lawyers are on pace with keeping their trial appointment with us. So I think they can be used very good. And like Judge Fry said, the more the lawyers utilize the deadlines that are set, the more effective a tool it can be.
Thank you so much. And to you, Chancellor Bryant, we're going to talk just a little bit about pretrial litigation. A question to you would be, what percentage of cases, or alternatively of claims, are you seeing disposed of in your court via summary judgment?
Well, I do think that there are more summary judgments that are filed now than there used to be, even if they're motions for partial summary judgment. And I do see some that are unnecessary, and that it makes me think, it makes me question whether you think you know what you're doing if you file when there's an obvious question of fact out there. There's some things that are just inappropriate for motions for summary judgment. But there are times when they are useful, and they're very useful. I tend to get a little frustrated in the management of those. And you saw Justin's motion to dismiss; those have been typically lately my motions for summary judgment. And so I don't want you to file repetitive motions for summary judgment, or have two filed while I've got one under advisement and I'm trying to rule on it, or filing a motion to amend while I'm just heard a motion for summary judgment. So because I don't have the file, because I have 18, 1900 cases, I may not know what you're putting in the file while I've got something under advisement. And, there is that case out there that says, well, the judge didn't rule on that motion to amend before they did this motion for summary judgment. So I think sometimes if the lawyers can just be cognizant of the fact that we're back at what Mary called our own time management, then motions for summary judgment can be useful, even if they're partial, even if they're just for one or two issues.
Thank you. To you, Judge Parks, I'd be curious, do you find in your court that summary judgment motions, you're able to frequently rule on those? Or do you find that frequently the responding party says, hey, Judge, I need some discovery, and that things get hung up? What's been your experience in that regard?
I think we all see some of both of those. I mean, I think sometimes you have people file motions for summary judgment quickly after the filing of a complaint and all the discovery hasn't been completed. When I see the response that we need more time, about half of the time that's not properly supported with an affidavit as required by rule, I think 56.07. And it needs to be. It's not it says it shall be supported, and so you try and be kind and say it's not supported. If you want to go ahead and file that, and I'll try and catch it on the front end. And most of the time, I find that the lawyers who have filed a motion for summary judgment, if it's a legitimate, they need to take so and so's deposition, they'll agree to continue them as long as the motion for summary judgment is reset. So I see those quite often. I think, like everything else, they're necessary sometimes, and sometimes it's now if they reset it a second time and the person who wanted additional discovery hasn't done any discovery, then I'm probably not going to give them another reset. I'm just going to say, I'm sorry, I gave it to you the first time. I'm not going to give it to you again. You didn't take anyone's deposition in the last 120 days. So that's how I've handled them, I think.
Thank you. To you, Judge Angel, shifting over a bit to discovery, are there any insights that you can share with practitioners about how they ought to handle an issue over a discovery dispute before bringing it to the court?
Yeah, I mean, I guess it's different with civil and criminal, obviously, but for the civil, they need to show proper communication with the other side and their request and so forth, and that they've made a diligent effort to obtain the discovery before they bring me into it. And then, the attorneys who are in front of me a lot know that I don't really tolerate that. So if somebody's withholding discovery or dragging their feet on it, you know, they're not going to like my reaction to what's going on, put it that way. And then, you know, also I've granted motions for sanctions, people not complying with scheduling orders and not complying with discovery. And you start doing that a few times, they get the message that, you know, we have to exchange discovery in a timely manner. We can't be sandbagging or holding things back, and we have to move the case forward. So that's how I handle it.
Very good. Just by show of hands, I would be curious, do any of you accept phone calls made by lawyers during depositions over discovery issues? If you do take those phone calls, would you raise your hand? Okay, so more hands than I thought. Just curious, I've never had to make that phone call. We've always seemed to work it out and preserve it for later. Would someone tell me what actually happens once we get on the phone? What's the court going to do with that issue?
My
Well,
response is, go ahead, Jerry.
No, go ahead, Jody.
No.
It just depends. Now, I will accept them if I'm available. I'm not coming off the bench to accept that call. Usually once they have time to cool off a minute, they can work that out themselves. But I will take it at a prescribed time, and my assistant or the clerk will just say, she requests that you go on with the deposition and hold that question. And when she gets a break, she will take that question.
Very good. Just a couple of last questions, a couple of trial specifics that practitioners frequently ask about. Are there any special considerations that the court might take on when addressing a motion in limine that has a potentially dispositive consequence, perhaps striking an essential expert or something to that effect? How does the court evaluate those motions, either the same or differently than any other? And I would pose that question to anybody.
I'm going to address the motion, the legal basis the same way, but you should bring it to me as soon as you know the issue. If you bring it the morning of trying to pull a trick on somebody, you may buy yourself a continuance and a chance for them to correct their issue if they would have had the opportunity if you brought it timely.
Good point.
That's what I would say.
I will say, and I know that 3 or 4 of us do healthcare liability cases, and periodically you will see a motion for summary judgment at the same time that you see a motion to strike the plaintiff's expert on a locality rule, which if they lose the motion in limine, or if they win the motion in limine, the moving party, then the party opposing it may not have an expert. And so I will, if I do that, and I've seen those, I'll go ahead and bifurcate that and say, I'm going to hear the motion in limine first, and then I'm going to give them additional time if necessary, if I strike that, depending on where we are in the scheduling order and how close we are to trial too. I've certainly seen them, but like Mary, I address them the same way legally that I do the rest.
Thank you so much. Brooke, how are we doing on time?
I have 1:02 on my end, so we can wrap things up unless there's any lingering questions or comments from the group.
Well, I'd be happy to, I don't know if there is a chat feature or a way for the audience to perhaps ask a burning question that they might have been holding this whole presentation while they've got this fabulous panel available to them. But if we could take just a few minutes to address some of those, that would be great. Can you see those questions, Brooke?
I can. Or there aren't any currently. Do you have your chat open, Allison? Are you able to
Pop it open here? Let's see. I don't see any questions on my end. I don't think that I'm overlooking any. If you had a burning question during this presentation and would like to ask the experts while they're all sitting here, please go ahead and send it over. Otherwise, I just want to take this opportunity to thank each of you for joining us this afternoon and to thank each of our esteemed panelists for their time, their attention, their incredible insight and wisdom today. We so appreciate it. And on behalf of the TBA, please do remember to submit your attendance so that we can provide you with credit for today's programming. And I think Brooke has some instructions on that.
Yes, just a bit of housekeeping. Thank you for the reminder, Allison. You will be able to certify this course in your TBA CLE account. So give us a couple minutes to work our IT magic and get that certify button available in your account, and you can move forward with your certification. But again, as Allison said, on behalf of TBA, thank you so much, everyone, for joining us. This was wonderful, and I so appreciate everyone's time. So y'all take good care, and I'll see you next time around.